Well, big changes could be coming for medical debt, but not without a fight. A new federal lawsuit is challenging the Consumer Financial Protection Bureau's rule to ban most medical debt from credit reports.
All right, this is very interesting. Ivan Herrera joining us now to explain who is suing the CFPB and what they're asking for. Good morning, Ivan.
Good morning. This one's a little interesting. You got to listen up for this one. So last week, we told you that the CFPB said this new federal rule would boost credit scores by 20 points for millions of Americans. However, industry groups say that the agency is overstepping. Now, Cornerstone Credit Union League and Consumer Data Industry Association are suing the CFPB, arguing only Congress can decide what goes on credit reports, and removing medical debt makes it harder for lenders, employers, and landlords to make smart decisions. Now, the rule also prohibits creditors from using medical debt in loan decisions. Now, the plaintiffs suing the CFPB claim this violates existing laws that allowed coded medical data, where patient privacy is protected, to be included in these reports. The industry groups argue that the CFPB based its rule on a 2014 report to determine that medical debt information has, quote, relatively limited predictive value, end quote, and that the report data is too old to justify this final rule. Now, the lawsuit also points to recent changes made by credit reporting agencies, like delaying the reporting of medical debt collections for a year, or like removing paid debts or small balances. Now, with 15 million Americans still owing $49 billion in medical bills, this case could change how credit scores are calculated and who can qualify for these loans. And I want to give you a little bit more about this. So the CFPB says this new rule would be good for consumers, as it would lead to rising credit scores and additional 22,000 mortgages issued per year. Now, the plaintiffs that are suing the CFPB, however, are saying that this new rule would leave them blind to important information about risk that these patients or these people who are applying for loans would take on. So the case was assigned to the U.S. District Judge Sean Jordan. He's a Trump appointee for the Eastern District of Texas, and this rule is still set to take effect in the 60 days after it's published in the Register. But if the court steps in, I mean, this could change everything. So we're going to have to keep an eye on it. But for now, the rule is still on the books to go in effect in those 60 days after the publishing in the Register.
Okay, well,
So, yeah.
you will keep us posted.
We will keep you posted. We'll keep you posted for sure. This is a brand new development. It happened right after this rule was announced. So we're going to keep an eye on it,
and we'll let you know. Imagine the amount of people that this is going to affect.
Yes, a lot, millions and millions of people, and millions of dollars on the line. So definitely, for sure. And we'll keep an eye on it. Thank y'all.
Thanks, Ivan.